right with you, right with you, right with you.
All rise. All jurors are up, Judge.
Okay, very good. Let's have Ms. Andrews walked back to the defense table. And do you anticipate calling any other witnesses?
No, Judge.
Oh, okay, very good. I'll have you rest in front of the jury. State, do you anticipate any rebuttal?
No, Judge, we don't.
Okay, very good. So defense, do you have any, now that you have rested, do you have any additional motions at this time?
We want to supplement our motion for the disqualification, and we also will make our second motion for judgment of acquittal.
Okay, we'll deal with the supplemental record regarding the motion to disqualify after the jury goes out. You can make your record. And so what's your second motion for JOA?
Second motion for judgment of acquittal, understanding that the standard has shifted now, so whether a reasonable juror could find that Mr. Andrews committed the offenses in this case. For all of the same reasons that we listed in our first judgment of acquittal motion, we're reiterating the very same things. This is a purely circumstantial case. This is a case where Alicia Andrews is accused of first-degree murder as a principal. The state has to prove that Ms. Andrews intended for the result to happen and that she did some act that caused, incited, or encouraged the intent to kill Mr. Charles Jones. And in this case, the state has neither of those elements for a reasonable juror to find that Ms. Andrews did that. The same is true for the conspiracy. There is no evidence that Ms. Andrews conspired with any of her co-defendants. She didn't know two of them at all, barely knew one of them, and the only one she didn't know was her boyfriend. Again, zero evidence that Ms. Andrews did anything to conspire with her co-defendants in this case to kill an individual. There's no evidence that she knew anyone was going to be killed. There's no evidence that she intended for anyone to die. There's no evidence that she committed any act that would further a conspiracy or a plot to murder Charles Jones.
Okay, State, what's your response?
Judge, again, there is overwhelming evidence in this case, beyond and to the exclusion of all reasonable doubt, that the defendant and her co-defendants conspired to commit this first-degree murder of Charles Jones, that there was planning, that there was premeditation, and that is the sole reason that all of them traveled here to Tampa, was to do this one mission. The video evidence is direct evidence. The hunting and stalking of the victim in this case is captured on video at 3 separate locations. There is coordination between both videos. The defendant is the one, her device, she is providing that device as coverage for her boyfriend. She's protecting him, so if this is investigated, that he will not be caught or found. So there is a specific purpose. She is being used as coverage as well as part of the surveillance team, so he is not alone walking in that parking lot at both of those locations. She is the one who tried to book the Airbnb together for them at Tampa. It is clear in that messaging that she's booking it for us, is the language that she is using. It is being booked for one day. They are booking it at a location that is close where the victim is going to be. She's not even with the defendant when that first attempt is made. And she lied to law enforcement about it. That is consciousness of guilt. She continually lied, specifically about the Airbnb when first asked about it. She said no. This is an interview that only happened within a month or so of this crime. There is no reason why she would not know exactly what those law enforcement officers were talking about. It's not until they tell her they have the phone message that she says, oh yeah, I did try to book it. I tried to get half-offs. It is very clear there is overwhelming consciousness of guilt evidence in this case where she is purposely trying to evade law enforcement. It's very clear from the phone evidence where she is gotten rid of her phone and she is talking to her a friend or her sister back at home watching the house where she knows law enforcement is looking for her, that they have her new device, and she is making fun that law enforcement doesn't really have the old device. Judge, all of that is consciousness of guilt. She is an active participant. She helped Isaiah Chance stalk that victim at multiple locations before they stalked him and hunted him down at the final location, and her and the defendant circled around the victim before the assailants came out and gunned him down.
All right, deny the second motion for JOA. There's enough evidence to go to the jury. Here is a copy of the final set of jury instructions, so I need you all just to quickly take a look at them, make sure there's no last-minute corrections we need to make, and then we'll come back in and do closing arguments, okay?